So we're live on YouTube. So thank you very much for this panel. It's a pleasure to represent IBCI here in this panel, to host a panel about a very important topic that is competition law and the value and the role of competition in transition economies. I have the honor to have this panel with three wonderful professors, Professor Jasminka, Professor Giacomo, and Professor Jorge. Professor Jasminka is going to start our discussion here. And Professor Jasminka is a professor at University of Zagreb, Faculty of Economics and Business, Department of Law. She has written, I think this is very interesting, she has written the first competition law textbook in Croatian. So that's very interesting. Her current research focuses on implementing competition rules in post-socialist economies. So this is the main question of the role of competition in a new environment. And she's the president of the Croatian Association of Law and Competition Policy and a member of ASCOLA and a member of ICCI Croatia Competition Commission. So a very beautiful resume. The word is yours, Professor Jasminka.
Thank you very much, Professor Klein, Vinícius. Thank you for the invitation. I'm really honored to share this panel with my esteemed colleagues. So obviously the full paper will be available later, but in this presentation, I would like to present some main ideas on the topic of the rule of law, market building institutions, and competition law in post-communist countries. So I will be drawing mostly from the experience of Croatia, but I will also try to consider developments in other countries such as Poland, Hungary, and Slovenia. So my presentation will focus on 3 points. The first one is the interplay between the rule of law and competition law. The second one are the challenges to building a credible market authority and the robust competition system from the perspective of the rule of law. And the third point I want to cover is the rule of law and judicial enforcement of competition. So as an introduction, the question is why these countries, ex-communist, ex-socialist, or so-called post-transitional countries can be presented as a moral or less homogeneous group, and what countries am I covering here? So in this presentation, I want to focus on the countries of the Central and Eastern Europe that joined the EU in 2004, the biggest group, 2007, this is Bulgaria, Romania, and 2013, which is Croatia. But I think the questions, the challenges are relevant for other ex-socialist countries that are currently in the accession process. So obviously these countries share common ex-socialist legacy features. So thereby they share common problems in terms of competition system effectiveness. Some scholars will argue that these countries still belong to the socialist legal tradition as a kind of a third legal system besides civil and common law. I'm not sure I entirely agree. I would note that certainly some of the characteristics of that tradition, of the socialist legal tradition, are still there, but more in terms of unwanted legacy. So preventing the full transformative effect of Europeanization, rather than saying that they do not belong to the civil law, European civil law tradition. Despite sharing some common features, these countries have obviously distinct trajectories in terms of competition system development. So for example, Hungary had well-developed enforcement and independent competition authority, but it recently encountered challenges in terms of the rule of law. Croatia had strong pre-accession growth, but then followed by post-accession decrease in enforcement activity. Poland's competition system was developing well, but its cartel enforcement record was virtually and is virtually non-existent. And you can read in the literature claims of an illiberal democracy lessening of the rule of law. Anyhow, despite these differences in development trajectory, I hope I will be able to present some common challenges to building an effective competition system in ex-communist countries. So first, addressing the interplay between the rule of law and competition law. So the rule of law concept, this is an overarching principle for democratic societies. It is somewhat of a vague concept. You know when it is there, yeah? You know when you see it, and you know it is not there when you don't see it. Anything in between seems hard to pinpoint. So quoting from the Statute of the Council of Europe preamble, the rule of law is one of the three principles which form the basis of all genuine democracy, together with individual freedom and political liberty. And according to the Venice Commission rule of law checklist, the fundamental requirement is that the law must be respected, but this in particular means that state bodies must effectively implement laws. So I note here that implementation is key. And what happens is that a lot of times rule adoption is in focus. So adopting legislation upon legislation upon legislation. And this is probably kind of, I would call it avoidance exercise. So if you cannot implement the law fully, you just reform it. So this perpetual reform, we've seen it, I'm not, yeah, I'm kind of old, but not that old. So we've seen it. It was one of the hallmarks of the communist times. So it's still plaguing us today. So the rule of law has clear implications for a competition law system. Let's say that for first, the principle of legality demands clear procedural and substantive rules in order to detect, identify, punish restrictions of competition in the market. Then demands of impartiality have consequences on the institutional framework in terms of institutional independence from political economical interference. But you can also talk about impartiality of judges in terms of the judicial review process. And lastly, the principle of due process under the Menarini case law, so the European Court of Justice case law, it demands full jurisdiction so that the reviewing court has the power to address decisions of the competition authority on questions of law and fact. So all of these questions come under this huge heading of rule of law and interplay with competition. And I think that in painting this picture of what's going on, we should be aware of the context. So we see or we saw two transitions, democratic transition and the economic transition. So by democratic transition, we mean simply establishing the rule of law. And by economic transition, we simply mean establishing functioning market economy. So to what extent do we have the rule of law, and to what extent do we have a functioning market economy? I mean, obviously, these countries joined the European Union, so they something must be there, right? But I would like to, as a scholar, I have to, say something about the challenges. So that's my job here. We should note that the Europeanization process was instrumental in how these two transitions played out. So by Europeanization, I mean the process of accepting and implementing the EU acquis, rules, procedures, standards, ultimately with the idea of changing the legal and economic culture of those countries. So I think 30 years after the fall of the Berlin Wall, times seems ripe to address any current challenges to the development of competition law systems from this perspective. The questions here are, is the transition over? Some call these countries post-transition countries, so it must be over. But I'm not sure it's over. So I will try to give some examples. So going to my second point that I want to address is basically what are the challenges to building a robust competition system. The first point I would like to make, I already, I think, said something about, rule adoption instead of rule implementation. So a lot of time and effort has been invested to adopt rules, change rules, introduce, more effective tools and so on. So for example, in Croatia, between 1995 and today, Competition Act was changed 8 times. And another change is currently in the legislative pipeline. So, there is a lot going on the agency, the competition authority, actually being involved fully in this process. So less focus on implementation, I think, therefore, and on the interpretation of the rules, which I think it should be, the reverse. My second point here would be the problem of soft enforcement. So we saw symbolic fines, really many commitment decisions adopted in abuse of dominance cases recently. So we have a lack of cases and lack of big fines. So I think this soft enforcement may not be, something you see in all of the countries. There are some more vigorous jurisdictions, but I think for a lot of ex-communist countries, you would actually see this. The third point, I think, in Croatia, we observe the problem of collusive culture. So in particular, if you look at the cartel decisions of the authority, you see the trade associations having this role as collusion facilitators in almost every case. And then the question is, having this transplanted cartel prohibition rule, is this cartel prohibition really countercultural? So here we come to this. My fourth point is the legacy problem. You used to have planned economy, and now you're where it was just business as usual to fix prices that firms would meet in the trade associations and then plan ahead, see what's going on, and then modify their behavior on the market accordingly. So there is still this mismatch between this cartel prohibition transplant and how do you really implement it. But when we speak about the legacy problem, people would just say, yeah, going back to communist times, planned economy, that's it. But I think you have to go even back, like archaeologists, they discover layers. So I think you have to discover layers upon layers of these events and historical, legal traditions and legacies. And going back to the mid-19th century, there is this Croatian professor, he's a law historian, who claims on the example of the Austrian General Civil Code, ABGB's Allgemeines Bürgerliches Gesetzbuch, if that means anything to anyone in German. So he claims that transplanting ABGB in Croatia, so that was, almost 2 centuries ago, this was actually a legal irritant. Why? Because in Croatia back then, you had the paradigm of cooperative property, so not private property. And then this General Civil Code came with this basic Roman law idea of private property and protecting private property, individualistic approach, right? But it clashed against the collective culture in the territory of Croatia, which was part of the Austro-Hungarian Empire back then. So you saw that clash between private property and cooperative property paradigm, which I think is really interesting when you see this, almost 200 years ago, 200 years later, in the context of competition law transplant, with the cartel prohibition not working as it should. And my fifth point would be that there are some features of the civil law system that I think are undermining the competition system. So one of the features of the civil law system is excessive formalism. So this, a very, very formalistic style of doing proceedings and writing decisions, of textual, interpretative, grammatical, interpretative method. This is really pronounced in Eastern and Southeastern Europe. So, for example, you can see many decisions by the European Court of Human Rights, which found violations of the right to fair trial due to excessive formalism. So here I have some good news. So because of the strong EU template, the Croatian competition authority was able to overcome these challenges, overcome this heritage under the influence of EU competition law and the Europeanization process, which I think is great. But then it's it's like a it looks strange sometimes in the general landscape. And then some bad news. You have in this civil law system processing of small claims is a norm. So the courts would even take into consideration even trivial groundless claims. Every claim has to be dealt with. So actually, I think in the area of competition law, this is preventing strategic case prioritization. So, the agency takes care of each and every initiative and loses time on small fish while, the big fish are out there, or I think they're out there. So then you have this phenomenon of what I would call random enforcement. And going to my third and last point, I would like to address the rule of law and judicial enforcement of competition law. So just as a general point, so bad news again, the EU Justice Scoreboard shows that the perception of independence of the judiciary is very low in Central and East Europe member states. So if you see this chart, then in the first part on the left-hand side are these more developed countries, and then on the right-hand side are these countries of so-called new Europe. I'm not sure if it's new Europe anymore, but at least the independence is not the perceived independence is really a problem, it seems. So since judicial independence is a fundamental element of an effective justice system, vital for upholding the rule of law, this also negatively affects the competition law system as well. What Croatian experience shows is there is a big difference between the competition authority and the courts in their ability to digest EU competition law. Okay, so the authority was a pioneer in this sense. So it started implementing EU legal rules as interpretative rules back then in the pre-accession period before we became a member state. So it was learning by doing, and it gained pretty much, a quantum of experience which was necessary. And the courts were and are still lagging behind in this respect. A current hot issue, which I think illustrates this point, is that in some relatively recent court decisions, deciding on some very important cartel decisions of the authority, the courts annulled these decisions, imposing a very high standard of proof in cartel cases, which many people, including me, think is in departure from EU standards. So this had an adverse effect on the authority, demoralizing, any future enforcement activity. So the enforcement intensity, I think, was decreasing because of this. So I think this lack of knowledge and awareness in the courts of EU competition law and its standards is a problem affecting overall competition system and overall enforcement. What is really interesting, so I'm maybe making some causal relationships here which don't really exist, but let me say my thesis. So before the authority got the power to directly fine undertakings, which was 2010, so the courts were deferential to the authority. So they had this deferential attitude. They were confirming the decisions of the agency. After the authority got the powers to fine undertakings directly, so the tiger got teeth. you see a wave of non-deferential judgments, so unfriendly attitude towards the cartel, in particular, decisions of the agency, which is a big problem. So I hope there is not a direct causality here, but I see we can make some relationship. So to conclude, I would like to point out that competition authority and the reviewing courts are not only bound by the rule of law principles, but also that they need to effectively implement the rules. And doing so, they contribute thereby to the advancement of the rule of law. So muted enforcement harms the rule of law and restricts the beneficial potential of full democratic and economic transition. So, in fact, I did not really answer the questions I posed at the beginning, right? Did we transition or didn't we? But I leave this for the discussion. And the key point, something I think in this preliminary meeting of ours a couple of days ago, I think it really made me think about the key point I want to make here. So I think actually that the key factor in our pursuit for a better functioning competition system is nothing else but the market. If there is no market, all our suggestions and recommendations for a stronger competition authority are possibly in vain. So what is actually the market? Market means rivalry. Market means uncertainty. Market means freedom of the contractual parties, to conduct whatever they see fit in the market. So my question there is there really a market in ex-communist countries? So in these countries, we see a strong involvement of the state in the economy. We see a lack, of individual freedom, lack of entrepreneurial drive. We see rent seeking. So here come the big words: corruption, bid rigging, clientelism, capture. It's easy to say it's the hallmarks of the communism, but is it really that the past regime left these marks on the society? And how can we effectively deal with these challenges, at this point of time without blaming our unfortunate past? So despite my fear of blasphemy as a competition lawyer, I will say it. So I think that the top priorities, in my opinion, should not be strengthening the competition authority, but strengthening the market. So here I really reached the limits of my expertise. So thank you, and I look really forward to the discussion.
Thank you. Thank you very much, Professor Jasminka. It was a wonderful presentation, very informative and very wide-ranged, talking about very important issues and had an important conclusion about the markets and the competition. And this was one of the main drivers of this panel. So I thank you very much in my name, in the name of the IBCI, for your talk. Now let's pass the word to Professor Giacomo. Professor Giacomo is a research fellow at the University of Florence. His research focuses on comparative and international civil procedure and complex litigation and enforcement. He has been appointed as a member of the expert group on modernization of judicial cooperation in civil and commercial matters by the EU Commission. So, Professor Giacomo, we are very happy to have you here. The word is yours.
Thank you very much. It's really not easy to go after Jasminka did such a great job, but I will try to build upon also a couple of things that she said, and especially the mention that she made to the rule of law and to the cultural element, because I think that she really focused on two elements that are very relevant. And as you said, I'm a scholar of civil procedure, comparative civil procedure. So let's say I'm a little bit of an outsider here. I will try to nonetheless present my view, especially on the issue of enforcement. And I want to start by comparing to advanced economies, and then see what this comparison can tell us for transitional economies. And I will also try to advance my PowerPoint in the meantime. Okay, perfect. You see that. Okay, so when I hear talking about the rule of law, I almost immediately think about the issue of enforcement. And we've been trained by our supranational courts, the Court of Justice, the Court of Human Rights, that an effective remedy, an effective enforcement is something that is fundamental. And so let's see what is the state, the health status of enforcement in these two main jurisdictions we're talking about. First of all, the main goal of enforcement, the goals of enforcement are various. It can be in the field of competition law, the restoration or the maintenance of competition in the market. But anyway, when we think about enforcement in general, it's either punishing and deterring certain conducts and compensating victims. Now, these functions normally are assigned to different kinds of enforcement. The main two sources of enforcement are public and private enforcement, and you already know where I'm going to. Now, if I think about competition law and public enforcement, I mostly think, well, also criminal, but mostly think about agency enforcement, what I could call administrative enforcement. And this is a kind of quite very effective enforcement, especially in advanced economies. Jasminka told us about certain shortcomings that we see in post-transitional economies. But anyway, we will see, I will show some examples very well widely known in a few minutes. We all know also that public enforcement suffer from certain elements, certain structural shortcomings, one of which is the scarcity of resources or the existence of a political agenda, which is neither good or bad. It's just an element. So there is a selection of cases, there are political pressure, there are other interests that could be taken into account. So if we think about a perfect and effective enforcement, we might want to supplement public enforcement with some form of private enforcement. Private enforcement being enforcement that is managed, that is stimulated by private actors. What are the ingredients to have a good private enforcement system? I show here certain elements, and everybody can recognize that these are very distinctive elements of the American experience, from discovery to class actions, preferably with opt-out, an entrepreneurial bar, incentives in the form of punitive damages, and so on and so forth. Now, we all know that private enforcement has many issues. I'm just here, I just want to stress the issue of accountability, because it will come handy later on. The issue of accountability is basically says, we don't know how private enforcement selects the cases, which cases are brought to courts, which violations are detected and then enforced. There is no coordination, and I wrote it's a little bit anarchic, if you want. So when you have private enforcement, you give a tool, but you don't know how this tool will be used, and you have less control on it. Now, my claim, coming to the cultural element, is that private enforcement, the American-style private enforcement, which is very well synthesized by the expression of private attorney general, is really something that resonates very well with the American culture. It's not my idea either. It's especially if you read this very interesting article of Professor Chase, he says that really the idea of private attorney general embodies all the features of the basic features of American exceptionalism, American culture, liberty, individualism, populism, and so on and so forth. So it's one individual that doesn't rely on the government, takes, let's say, the law in its hand and goes and find the bad guys. But I also think that underlying in the idea of this strong private enforcement, it's a belief, a reliance on, let's say, a true commitment on free market. And free market here is represented by this endless cycle. So everybody can enter the market, they can enjoy their life there, innovate, grow, they can sell the business, and then they can arrive at the end, the death of a business with quite an effective system of redeployment of assets. And with this true commitment, I don't need to worry about the effects of private enforcement, because whatever happens, however the law is enforced, if a player goes out of the market, means that it was a bad player, violated the rules, and then it's we get rid of him. So I think that there are these two basic ideas. On one side, private enforcement resonates with American values that are described there. And on the other side, there is an underlying true commitment about the principle of free market economy. Let's go now to the European Union. Now, we are talking about an advanced economy. We are talking about a place where the rule of law, as Jasminka said, it's evident. Let's say we can see that there is a rule of law, although with many defects, if you want. And there is also quite a developed system of competition law, a little bit younger than the American one, but quite an established one. And we can see that in the news, there are fines issued by the European Commission that are growing and growing and growing. Now, one of the preferred subjects appears to be Google, because these fines are now reaching 7, 8, 9 billion euros. There are many others. And also you can all see that there is often this issue of leniency. So one cartel member whistleblowing, which is an element that is counter to the private enforcement idea. Maybe we will go, we will cover it during the discussion. Anyway, leniency is very, very important in this field, especially, of course, in cartel prosecution. But the fines are really rising. So we can say fairly that there is quite a strong public enforcement. But if we turn our head to private enforcement, my feeling is that we are very behind. I'm putting there two examples. One is the truck cartel case, where the six main truck producers, European truck producers, were fined a record fine of 3.7 billion euros, very, very extensive fine that was also reduced by leniency, by settlement, by cooperation. So it could have been more. And this fine was because these truck producers were caught having a cartel, fixing inter alia also the price in a very long period of time, 1997, 2011, okay, 14 years of cartel. Now, 4 billion euros is a huge fine. And when you read the decision, it's nice. It ends like saying, okay, Daimler has to pay 1 billion euros, and this is the bank code that they have to transfer the money to. So it looks like an electricity bill, but it's not. 1 billion euros, please pay in 60 days. Anyway, but if you look at the number of potentially interested, potentially harmed companies, this is mind-blowing. The EU Commissioner for Competition, when commenting this fine, was telling that there is an average of 30 million trucks currently on European roads. Now, try to think about how many trucks this represents in 14 years, and what could be the harm, the possible compensation that can be claimed by harmed customers. The number is really huge. If we just limit to 30 million trucks and we calculate a 10,000 euros damage, which is an average of 10% on a possible truck price of 100,000 euros, you have 300 billion euros. And this is just a snapshot, it's not 14 years. And then we have a second case that is interesting. It's not hardcore competition, if you want, but it's interesting because it was on the two sides of the ocean. So the Volkswagen diesel emission scandal. We all know what this is about, and what you might not have focused on is that in the United States there were around 500,000 cars sold by Volkswagen, and the public and private enforcement cases were settled very soon. Huge public fine, $15 billion, but also huge compensation for private parties. Of course, there were class actions, consolidated in multi-district litigation, and then 500,000 individuals settled with 10 billion euros, and the average was repurchase of the car or repair, plus a compensation of $5,000 or $10,000. Okay. Now, in the European Union, Volkswagen sold around 8 million cars. So it's around 16 times the number of cars that were sold in the US. But we all know that there was no such huge program of compensation. There was something. There was recall and repair. And we know that in member states, a certain number of initiatives were launched. In Italy, we have 90,000 car owners. In Germany, around the same number, and I believe it was settled for around 1 billion euros. And you have other initiatives. And you also have initiatives against the truck cartels. It's not that you don't have, but they are very scattered, very few. So from the point of view of private enforcement, I think we are very well behind. And you can see this press release of 2018 that says that the European Commission was having a dialogue with Volkswagen. So the attitude is very different from what you would expect from somebody that was not allegedly, but admittedly cheating on emissions. We cannot say that nothing is being done to bridge the gap. You all know about the 2014 damages directive that tried to promote follow-on damaged activities, but you read recitals 13 and you read that this directive should not require member states to introduce collective redress mechanism, and also should not lead to overcompensation. So you see how cautious is the European Union. We don't have strong collective redress mechanism, but in a directive that is specifically on antitrust damages, one of the fields that calls for collective actions, like by its own nature, no, you don't want to require this. And finally, in 2020, you have the directive on representative action. So even the wording repels the class action, no, representative action for the protection of collective interests of consumers. This is specifically for consumers. So not necessarily antitrust damages. And when you read it, and I summarize it with this sentence, we don't need no US class action, because you read really, literally, it's not clear what it should be, but it's very clear what it should not be. It should not be US class action. Okay, so this is very strong, very, very perceived in European Union. And I have to tell you honestly that for many years I've been very critical about this approach, and I'm still am, because I think that there is a huge gap in European Union about enforcement, private enforcement, which goes to compensation, which goes to deterrence. But When you get a little bit older, you start thinking about other aspects, and let's see what comes out. So partly, I think that the issue is political, and it's technical also. You don't want necessarily the private component to care about the deterrence. Europe says the private component should care about compensation only. And this is a political decision. You can like it, you cannot like it, but it's a political decision. But my suspicion is that the coldness of European Union towards private enforcement shows something different, shows the existence of a cultural bias, if you want. So when you think about this endless cycle, I think that in Europe, we don't really believe about it. We don't believe that death is redeployment of assets. That really, if a company goes out of the market, if Volkswagen goes out of the market because it blew off very badly and it broke the rules, then something else will enter the market. And not only we don't think that death is a new birth, but there is a strong, strong feeling in Europe about innocent parties, about stakeholders. So what happens if Volkswagen is bankrupt because of a violation, because of an enforcement initiative? What about the employees? What about the banks? What about the investors? What about the contractors? What about the network? Everything will fall, okay? So my feeling is that there is really a cultural bias. There is not a true commitment to all the principles of the free market as we see in the United States. Maybe this is the discovery of hot water, as we say in Italy, but I'm starting to believe that really we cannot, or we shouldn't look to an answer in the law, because the rule of law is there, the system is an advanced system, is mature, so I think that there is something different. And if you think that in my language, in my own language, the idea of bankruptcy is translated with fallimento, which means failure. And that since until, let's say, the 90s, if you had a failure, you couldn't vote. You were deprived of your political rights for a number of years, no? And the idea of bankruptcies evokes this idea of banco rotto, these bankers in the 15th century that were broke, they were broke their bank because they did something wrong. So there is really a disvalue in this idea. And in Italy, only in 2019, the bankruptcy law was reformed to exclude the word fallimento, failure, and now it's replaced with judicial liquidation, judicial winding up. No, so again, I think a very strong cultural element. So, having done this journey through this comparison between the American system and the European system, I think that we can fairly say that it's not a matter of legal ingredients. It's not a matter of whether you have class action or whether you have contingency fee, entrepreneurial bar, discovery. Of course, all these elements matter. But what I think should be done is to clarify, to decide what are the principles, what is the degree of commitment, what is the market that you want. Do you want the state to be a player in the market or not? Do you want to protect small businesses or not? Do you care about stakeholders, about innocent parties, or do you trust the hidden forces of the market to put everything in place? And as I say, as I try to show, competition law seems, and it is, a very technical branch of law with a lot of formulas, a lot of very difficult concepts to grasp. But it's not neutral. It's not that just numbers and precepts of law. It has a meaning. It has a value that is a value for society. There can be different ways of reaching the certain goals of policing the market. And there are other elements that can be taken into account. So to conclude, I think that For sure, private enforcement is something that is for mature economies, for mature markets that are strong enough, but it's not enough to have legal ingredients. You need a cultural commitment towards the free market. You need to really trust the free market to make the work for you. Thank you.
So thank you very much, Professor Giacomo. Very nice presentation too. And you picked, I think you are very clever in picking this topic of private enforcement to illustrate these differences between systems. More centralized systems are public enforcement like Europe and the United States, and showed us a lot the role of cultural factors and institutional factors in competition law. Now I'm going to pass the word to our last speaker, Professor Jorge, who earned his law degree at University of Chile Law School, had a Master's of Law at Harvard University, and a Master in Trade Regulation at NIU. And he is a professor for Antitrust and Competition Law at University of Chile. So thank you very much, Professor Jorge, and the word is yours.
Thank you very much, Vinícius. It's a pleasure being here. Thank you very much as well to the IBCI and to my friends Eduardo Molan-Gavan and Juliana Dominguez. My idea is to share with you in the first part of my presentation an experience of a jurisdiction with which I'm very familiar. Of course, it is Chile. And I think this experience is useful to understand what Jasminka stated, that to achieve in the end an efficient state of enforcement of competition laws, it is unavoidable to have a strong market-based economy, but also a strong rule of law. And in the end, what Giacomo also said, a competition culture. And Chile reflects this pretty well in its competition laws evolution. The country first adopted its first competition act in year 1959. It was the first competition act in Latin America. The country adopted this competition act because of a recommendation of an American missions of experts, and the goal was very particular. It is totally different than what inspired competition laws in countries like the US, which was in the end protecting democracy because of the power that trusts, cartels had there in strategic sectors of the economy. It is totally different from what the European Union tried to achieve in the end to reach this economic integration. In Chile, the objective maybe was more plain and simple, and it was to combat inflation. The country had a very high inflation during the 1950s, and one of the recommendations of this American mission, inspired of course by the success of the Sherman Act, the Clayton Act, and the antitrust laws, was to recommend. But the fact was that Chile had a centralized economy. For example, there was an agency that was in charge of regulating prices in all essential goods. As an example, well, all the goods that you go to buy in a usual purchase at a supermarket were fixed. We lived in those years under a centralized economy. So you can imagine that the law was barely enforced. And that was during the 1960s and even during the 1970s, because as you may know, in 1973, we had a strike of militaries that may begin a dictatorship led by Pinochet that lasted from 1973 to 1990. And it is very curious that in the very first year of the dictatorship, the competition laws were renewed. We had a very similar but new Competition Act that was in the end renamed, but the provisions were mainly the same. The institutional framework, we had a competition commission. At that time, it was very similar to the one that was created in 1959. But there was at least an intention to give more importance and to give a signal from one of the main things that the militaries wanted to combat at that time, that was the failure of a centralized economy. So one can see that in the 17 years of the dictatorship, the law was enacted, but there was clearly an under-enforcement of antitrust laws, and there was very limited institutional capacity. At that time, for example, there was a competition agency with very limited powers and budgets, despite the fact that we had imprisonment as a sanction, like in the Sherman Act, not only for cartels, but also for unilateral conducts, which was really strange and crazy, but inspired in the end in the American law. And the fact was that the institutional bodies were not clearly independent. We had a sort of competition tribunal integrated by 5 members, and 2 of them were part of the government, were head of agencies. For example, the equivalent to the Securities and Exchange Commission, the Internal Revenue Service, were some of the members of the Competition Commission. And a landmark was in year 2003, when there was a clear amendment to the Competition Act, and those commissions were replaced by a competition tribunal. And Chile adopted a very particular design, institutional design, because there is a competition agency known as Fiscalía Nacional Económica, National Economic Prosecution Office, which is, I would say, the competition agency. It has powers to investigate anti-competitive conduct, but does not have adjudication powers. So at that year in 2003, there was created a competition tribunal, which was in charge of adjudicating all the cases brought by the competition agency, by the Fiscalía Nacional Económica. And the competition tribunal was integrated by economists and lawyers, permanent judges, independent ones. So that was a clear signal in democracy, under a clear rule of law, and having had some, I would say, not truly important cases, but relevant ones still in the enforcement of antitrust laws, to make the Chile's antitrust system to move forward and to protect competition. And from that year, Chile sharpened its enforcement because it was clear that the agency had a lack of powers to investigate collusion. So in 2009, the country incorporated powers to carry out down rates, to carry out wiretapping, and also a leniency program in the Competition Act. And that triggered, I would say, 3 very important cases during the period from 2009 to year 2015 in very relevant industries such as pharmacies, poultry, and tissue. And with those three cases, we saw a sort of creation of a competition culture in the country. Consumers and politicians, in the end, got to assess and to value the importance of competition enforcement, and started to understand the meaning of competition, the meaning of competition and the meaning of collusion, which was a strange word. I remember when in year 2003, I wrote my thesis in law school about collusion. It was a strange word that there wasn't literature here in Chile. And 2 or 3 years ago, I heard the head of the competition agency saying that if you look in Google, in year 2015, collusion was one of the 10 words that was more searched in Chile in Google for all the users located in the country. But besides that, we saw that for those important cases, consumers protested outside of pharmacies. Consumers asked the consumer authority to help them to claim for damages, which, well, during these last 3 years, most of the cases are pending, either in the settlement arena or in the courts. The damages claims, but consumers are more aware than they used to be in the 90s and the 2000s, the first decade. So the next stage was 2016, when in Congress it was discussed a bill of amendment to the Competition Act that I would say updated Chile's Competition Act to the state of the most developed jurisdictions. We added pre-merger notification that has been pretty well implemented by the competition agency, and added an extremely important tool for competition enforcement that we didn't have. Also, the competition agency has market studies, a power to carry out market studies that from a public policy point of view is truly important. There were some amendments on private enforcement on damages. The competition tribunal, through a follow-on procedure, is in charge of deciding on damages claims, and there were some other provisions on interlocking. And besides that, from a political point of view, the most important amendment was criminalization of collusion. We had from 1959 to 2003 criminalization for all the anti-competitive conduct. In year 2003, when the competition tribunal was created, Congress decided to increase the amount of fines, but abolished criminalization for anti-competitive conduct. And in line with the importance that competition laws started to have for the community, for the politicians, it was clear that people started to demand criminalization of collusion. It wasn't logical from a political point of view to have high penalties for other economic offenses, but not for collusion. And Congress adopted some provisions on this. So from this quick evolution that I am telling you, we can know that the evolution of the Chilean system was not influenced by what you could call a clear exogenous force. Listening to Jasminka, and from my limited knowledge on European competition law, I could guess that the European Union or the interest to join the European Union may have played a role in those jurisdictions to move to a market-based economy, to move to adopt some institutions like competition laws that are part of a market-based economy. But in Chile, mainly, the evolution of competition laws is a fruit of reaching conviction about the advantages of competition and the market. It has taken time, but we can see that having a market-based economy, when we return to democracy, and because of the second part of the dictatorship, and then because of the conviction in politicians and in the people in the end about the advantages of competition, now we are seeing a strong competition system, competition law system. And I think this should be an important factor to preserve what has been what I consider a successful institutional model under the current crisis of capitalism that, well, the world is facing, but also Chile. And in Chile, this challenge is especially particular because on next April of year 2021, the country is going to start the discussion of a new constitution. There will be a constitutional convention and all the aspects of the social agreement are going to be discussed. And of course, the role of the state in the economy, if there should be in the constitution some provisions regarding the role of the state, the economic model that the country should follow, or if it should be neutral. But there will be, of course, a debate there. And unfortunately, I can see that the competition institutions have done their job to have a strong work to be presented, I mean, to the people that are going to have this conversation, sort of conversation at the convention. That's the first part of my presentation, and then I would like to add some points to what Jasminka and Giacomo said about some priorities or some institutional characteristics that should be considered in a transition economy. The first one is about the priority in the enforcement in transition economy. Of course, anti-cartel enforcement should be there, and it is said to be maybe the priority of competition laws, but it is particularly important, in my opinion, to consider that in a transition economy, we should consider and give high priority to the enforcement on provisions that deal with abuse of dominant position, because you have state-owned enterprises or recently privatized companies that are going to have in the end monopoly power by definition. So the agencies, young agencies, should at some point deal with this potential abuse of dominant positions. We know that proceedings, investigations or trials regarding abuse of dominant position are really complex and costly. But the agency should deal with this. Maybe commitments should be used pretty often, but you have to regulate those abuses, mitigate them, and ideally sanction them. And then a point on capacity building. Of course, to achieve good and not too slow results, capacity building is needed. It seems key to have, in the end, independent institutional bodies that can investigate state-owned enterprises that before privatizations occur. In a transition economy, you will see in strategic sectors of the economy these state-owned enterprises. And if you don't have independent competition agencies or tribunals, you won't be able to enforce competition laws against those SOEs. Additionally, I think it should be useful that competition agencies can practice regulatory review from a competitive standpoint to diminish regulatory barriers to entry and boost competition. This might also be complex. We can see, and under Chile's experience, it happened that the Congress didn't give enough budget to the agency, but I think regulatory review must be part of the toolkit of the agency, definitely in this case. And finally, transparency and trust seems also particularly relevant from a double point of view, I would say. First, to enforce competition law provisions that are inherently vague. One can see if you open and read maybe almost every competition act all over the world, provisions are going to be vague. It will give a lot of discretion to the agency and the courts. So transparency and trust is particularly important, more important than in other areas of economic regulation. And then it is important to have transparency and trust to achieve evolution in the enforcement and to add new features to the law that particularly require transparency and trust, such as merger control. One can see in Chile that transparency from the agency to deal and negotiate with the merging entities under merger control is particularly important, and trust as well. Trust to negotiate, to enforce the decisions, and to believe in what the authority is doing, and to give the possibility to politicians and consumers to believe in the market economy. It is also extremely important. Thank you. I am open for the discussion.
Thanks very much, Professor Jorge. You showed us a lot about how competition played an important history in Chile and the specific features of Chile, and also provided a very interesting and informative discussion of the previous presentations. So congratulations, and I think this panel shows the commitment that IBCI has with diversity, because you have different views from different countries, and I think you're going to have a good discussion. I'm not going to abuse my power as moderator, and I'm going to start with the questions from the audience. So we have a very important, a friend and a Professor Vicente Bagnoli, who is an antitrust scholar here in Brazil. He has a very important work. He is the co-director of the Scholar chapter in Brazil. And he asked I think the three of you a question. Should competition authorities in transition economies focus basically in competition enforcement, or should consider other goals, such as industrial policy and labor issues? And to put a little more, and if you see the country evolves, like Chile is an example, Croatia, sometimes in a part of the history, the country is like more market-oriented, then becomes maybe in the constitution of Chile it becomes more market-oriented or more state-oriented, and when it do these changes of institutional feature, do you think these changes should impact the antitrust goals, not only for transition economies, but also from the different parts of the time of the country, when the country is with a special directive in political way, and maybe there is a political decision changes? So who wanna start? Who wants to start? Jasminka.
Okay, it's a tough question. Thank you, Professor Bagnoli, for this one. I think here let's start from the normative framework. I would say that normative framework in Croatia and I think in other post-socialist countries would not give so much leeway for the application of other goals, the wider policy goals such as industrial policy, labor issues, and so on. But so I think the core mandate would be, the fewer antitrust elements of analysis would be employed. But this is, not to say that in individual cases these matters would not be taken into account. So the failing firm defense, then the cases where you see in the background these issues, but I haven't seen any cases where our competition agency said, really blatantly that it engages in the, assessing these other policies. So I think it's a very slippery terrain for the antitrust agency to go into, especially in a system which doesn't have well-established enforcement tradition, such as Croatia and other post-socialist countries. So I think this is my own opinion. I think you should stick to your own, field and discuss antitrust issues, and then see how this plays out with other authorities and the government. So I think actually what I want to say is that I observed this problem that the government doesn't really recognize antitrust policy as part or a complement to its economic policy. So it would be somehow unnatural for the antitrust agency to engage, into dealing with wider policies and goals. So I think first you need to establish what is your main core task. Show why competition, market structure, and this process of competition is relevant for your country. So I think that's, sorry for not being very articulate, but I think you should be first starting from your core mission, and then this discussion is like a second level maybe.
If I may add, first of all, let me also thank Giuliana and Eduardo. I'm a very bad guest, and I forgot at the beginning. But I think two things. By reading literature, the factoring of external elements into antitrust or competition analysis is a sign of a transitional economy, meaning that if the antitrust authority allows a merger, if you keep the occupational level, or if you do not damage our, let's say, industrial policy, this would appear to be a sign of not established system. So a system that is not devoted, not well organized. But I also agree with Jasminka. Not only the idea of my presentation is that the system as a whole factors these elements in the broader analysis. But if you think, for instance, at the controversy between the US and the EU in the merger of Boeing and McDonnell Douglas, I might misspell the second name, but where US approved merger, EU did not approve the merger, and then there was this querelle that said, okay, we in the US protect competition, you in the EU protect competitors. No, this whole idea is. So you can see that even at very advanced and mature level, there are concerns that are taken, and at the end of the day, as I hope that I showed, these are not neutral concepts. These are not neutral decisions. Sometimes they are technical. Sometimes they are based on, or they are often based on rational elements, but they are not value neutral in my view.
Yes, I think this is a very important matter, not only in transition economies, but in more developed jurisdictions. And I think that, and I tend to agree with Jasminka in the sense that the competition agency should have a clear mandate. The leaders of the agencies, of the competition agencies, should have the ability to defend the enforcement of that clear mandate. And then it appears again the importance of having a competition culture, the importance of being backed by politicians regarding the importance of competition. And I could tell you that in Chile, we are having a recent debate regarding the investment of the Chinese government, Chinese mixed enterprises in some strategic sectors. Those Chinese enterprises have invested in Chile, in the sanitary sector, in the electric sector, and well, we since 2017 we have merger control, so it is not the first investment that those Chinese enterprises have made in Chile, and these days it has appeared in the news that they are interested in increasing their shares, their participation in the electric sector, and it is likely that they will have to notify the competition agency, and in the end it appears in the discussion the issue of national security, influence of external economies, and this is an external factor out of the mandate of the competition agency, definitely. But in Chile, we don't have institutions, agencies that deal with this issue. In the US, for example, the president can take some decisions on this matter, and there is an institutional framework, and not in Chile. So this has created an interesting debate on what to do, and one can see at least that because of the reputation of the competition agency and the competition system, one can defend that the agency has a clear mandate, and this issue should not be encompassed by the agency. But still, you can see that they are dangerous issues that appear in the end that could put into risk competition enforcement. And then I return to the ability of the leaders of the agency, of the competition agency, to deal with politicians, to pass the message about the goals of competition law, that it is really important.
Thank you. We have another question, and also from a very important scholar, and it's from Professor Magali Eben, who's going to speak tomorrow. Will speak in the conference. Also, Professor Bagnoli is going to be at the conference on Friday. So, Professor Magali asked this: "You protect competition, you protect competitors," is a sentence I often give to students as an essay question. Is this a correct way of framing the US-EU distinction? So do you think this is a fair way of showing? Because I don't know, I just want to add something. This European Union idea is it's a lot of convergence on for instance, the role of national authorities and private enforcement, as Professor Giacomo said, isn't different in different cultural systems and different nations.
I will start since I raised the point. So I believe that I'm sure that when it was said back at the time, it had a derogatory, denigratory meaning. Let's say we just care about the effects on the market, and whether the price and the output for consumers will be better or worse. You are now concerning that you're losing the number of players in the market and so on and so forth. I'm not in the position of answering such a difficult and interesting question. And what I want to say that perhaps in Europe, there is a little bit more focus also on the competitors. So it's not purely an effect on the output, on the price for final consumers, but there might also be concerns that go to the nature of competitors. One issue, for instance, that sometimes it's raised is whether it should be or not a policy or a feature of competition law to protect small businesses, for instance, when you have a new giant mall entering a neighborhood that just do the best price for consumers, but in the long run will maybe have the effect of driving, even without predatory tactics or with exclusionary tactics, will drive many small businesses out of the market. So I believe that perhaps there is a little bit of truth to this statement, but I rest my case because I'm really way out of my league.
Okay, I can go next if that's okay. So thank you, Magali, for this question. It's a $1 million question, right? So I always recall when I teach the Bronner case, the Oscar Bronner case to my students. So this is, as you know, an abuse case with so refusal to deal, where the big competitor refused to allow access to his home delivery scheme. So these were like a big newspaper group and then a small competitor. So, you know, during all of my years of teaching this case to students, it would almost without exception, everyone would say, no, he should, you know, he should allow access to this home delivery scheme. And I'm always like trying to say, yes, but you know, the point, like the Advocate General Jacob said, the point is not to protect competitors, but competition. And then students are looking at me like she must be crazy, you know. So you know, we're all, I think, trying to give our own contribution is making to give this message across that you know, the goals of competition are really not to protect the weaker ones on the market. It might be a cultural issue, you know, this collectivist framework that, you know, poor smaller competitors, you know, they are outcompeted. But if you follow like this big discussion on big tech, on the digital giants, you see actually the European Union saying exactly this. You know, there are strong structural problems on the market, and you know it goes against my own experience, my own education, because when I was taught at the University College London, you know, like back in the many years ago, competition law is not about structure, you know, except for the merger control. You know, competition law is about behavioral conduct on the market. So there are so many controversies here, and yeah, we could go about this for an hour, but this is what I wanted to say.
I would like to add on what Jasminka said regarding the enforcement against the largest technological corporations, Google, Amazon, et al. That, well, there is this sort of mantra protecting competitions and not competitors. And in the US, I will give my view on the US. One can see that the enforcement of unilateral conduct has been quite more restrictive than in Europe and other jurisdictions. And some literature mentions that might be part of the consolidation of these players that, of course, have created benefits, but we are also seeing some disadvantages from a competitive point of view. So maybe we will have to see during the following months in the cases that have been started, the Google case and the investigations that apparently are ongoing under Facebook or Amazon. What happens on this more lenient approach that has created a sort of a paradox of protecting competitors, giving them the ability to be these giants that, well, if they are efficient and benefit consumers, that might be okay under the traditional paradigm, but that is being challenging, and we will have to see the results of those challenges.
Thank you. Well, if there is any more questions from the audience, I'm gonna ask one question from myself, and then I think you can end the panel. The question I would like to ask is like this, and it's more for Jasminka, but can be answered for all of you three. And I think Jorge has mentioned that question in his presentation. It's like Croatia had when Croatia entered the European Union, Croatia maybe had wanted to have more markets and more competition. So I would like to ask, how was the role of the entering European Union in making more competition authority, more competition, and giving more authority to the competition authority, more powers and things like that. And sometimes having history like different frameworks. For instance, I remember Japan had an imposition of competition law after the war. So it's different. You had a transplant, a legal transplant, but was not wanted. And I don't know if you can compare these different situations when you have this external force that helps you in that direction, and when this external force has some coercion and tries to impose something. Competition law.
It's a very good question. So I think in the pre-accession phase, there was this huge incentive in complying with, everything. So, but the European Commission played a crucial role here. So actually, the Croatian authority during this pre-accession period got all the procedural instruments that were needed for a good enforcement. And in this pre-accession period, we saw a gradual but steady increase in enforcement activity. So you had cartel cases, few, but steady every year, one or two. You had abuse cases, you had merger control cases, which were well established from before. But then what happened, and this was a surprising turn of events, after we acceded, you saw a decrease in activity. So I tried to explain the reasons, I think the reasons in my presentation, but what happened is after this huge incentive was gone, after this pressure, you have to change the rules, you have to show track record, you have to, then, there was this fatigue, post-accession fatigue, I think, which can explain partially. But not to paint this simplistic picture here, I think that the agency was trying to continue with cartel enforcement. So in the years after we joined, so 13, 14, 15, 2015, there were a couple of big cartel cases. You know, Jorge was speaking about the importance of big cartel cases. And what happened, that the huge advocacy potential and awareness raising potential of these cases was really blown up by, was deleted by the judicial review decisions, which said, you know, the courts didn't think it was a cartel. And you know, these are really pure direct contact, like hardcore price fixing cases, nothing really, you know, extraterrestrial. So these were cases where parties would you know, sit around the table, the competitors would sit around the table, let's say the private security service case, and they agreed on a portion of a price. So how to calculate portion of a price. And then the court said, you know, you have to go into the, did they really sign the the minutes of the meeting? Did they, you know, is this calculation of a price really price fixing? So looking at the European standards, it's funny, but it's not funny. So the consequences of this judicial review process were not really funny for the were not at all beneficial for the future trends, enforcement trends in Croatia. So I think the problem is, as Jorge said, you know, a strong independent body that has the budget and human resources, and then you need to have also courts that understand what's going on.
Giacomo wants to say something.
Yeah, just a couple of words. It's an interesting point, and a couple of thoughts that come from our general comparative law class. And the first is this, Jasminka mentioned the BGB, and want also to go a little bit back in history. And if we think about the Code Civil, the Napoleon, the French Civil Code, that was spread all over Europe at the beginning with the use of force. So it was force upon the states. And then once the troops were gone, the states said, you know what? It's a good product. It works. It's effective. It's better for our societies, and kept it. And so this, I think, explained that effective instruments, effective institutions can have a life of their own. And ineffective institution is a little bit more difficult. But in the context of this transplant that Jasminka told us about very well, with a lot of details, I think what is very interesting is that you have a set of rules and institutions that should be similar across different states. So you really have a measure to see if this transplant worked, and how, and Jasminka just did that, where it didn't work, why. So from a comparative law perspective, is really a very interesting example of legal transplant. Can it fail? Can it succeed? So really interesting.
I have a question for Jorge, if I may.
Oh, of course.
Of course.
So I was just wondering whether the crucial thing about the success of the Chilean model is the fact that you have this prosecutorial model, right? So you have Fiscalia, which is not really under a lot of stress because adjudication powers are taken away. So you have the sole purpose of Fiscalia to investigate a case, to bring facts and evidence in front of the court, and then someone else will decide. So do you think that this is a crucial element? And you have countries like this, jurisdictions in Europe, like Austria, I think, and Sweden. So I was just thinking whether, you know, maybe changing the model, the institutional design would help us in having a more successful system. Thank you.
Thanks, Jasminka. It's an interesting question. But it doesn't have a clear answer, I would say, in the sense that, well, it creates positive externalities to have a design like the one we have in Chile, in the sense that we don't have the typical questions on or critics regarding due process, for example, and sanctions are more legitimate in the sense that they are imposed by an independent tribunal. Then in the design we have a fast track to a Supreme Court. If you are not satisfied with the decision of the competition tribunal, you appeal directly to the Supreme Court, and the Supreme Court has the last word in Chile regarding competition infringements. But I am not sure in the sense that when you have a more clear and robust competition agency, that it is clearly known in the system as the competition agency, because it has all the powers that traditionally a competition system has. I think that's also positive for the enforcement, and I want to be more specific on this. The Fiscalía Nacional Económica, the agency, until 2016, didn't have the power to make recommendations for regulatory changes. You had to pass through the competition tribunal, and the competition tribunal had to issue those recommendations. And that was not a happy decision, because it has created a lot of inefficiency. Now both bodies have the power. Fiscalia obtained the power because they were granted the power to carry out market studies, so it would be totally ridiculous that they wouldn't have the power to make recommendations directly. And you have to add to the menu of the current state in Chile that the Fiscalía Nacional Económica now is in charge of merger control. Fiscalia receives the notifications, and Fiscalia has the power of adjudicating, of deciding on mergers. It can authorize mergers, it can impose measures proposed by the merging entities, or it can even prohibit mergers, and there is judicial review before the competition tribunal. So I would say that on infringements, it is a good design. It has given us clear benefits in terms of due process and legitimacy of regarding imposing sanctions. That could be even more important because in 2016, the law on sanctions was modified, and now we have a system of flexible fines without a fixed limit. The fines could reach up to twice the benefit obtained by infringers, or 30% of the sales involved in the infringement during the whole period of the infringement. So that could be important in terms of the legitimacy of the sanctions, because otherwise it could be risky. Accused undertakings could claim before the Constitutional Court that, well, there are troubles regarding due process and potential infringements to the Constitution. It's an interesting question, but I truly believe in this bifurcated system. You can see it in Canada. In Canada, And well, people who work in the agency, I used to work for the agency, and I went to international forums at the OECD, for example. We always laughed with the Canadians and said we have to work more to obtain fines than in other jurisdictions. But in the end, it is more stable and secure.
Thank you, Jorge. So I think it's time for us to end this panel. It was a wonderful conversation, and for me, I could talk more, but I think it's time to end. So I want to give like 1 minute for each one of you to say your final words, and I want to thank you a lot from IBCI for this opportunity to discuss this matter. And this was a very nice panel, and I learned a lot, and I thank you so much. So I think you can start from Jasminka, who spoke it first.
Okay, thank you so much. Really, Vinícius, it's been a pleasure being in Brazil for 2 hours. So at least, on Zoom. So I would just like maybe to reflect on what Giacomo said in his presentation, that law system has to resonate with its values. So I think you were speaking about the US system. So I think that's really important. And this is actually, I think, the problem in post-socialist countries, that the norms, the normative framework is not in sync with the values. And I always hear this story about the European Union. So Europe was the country where the firstborns would stay here, inherit land and everything, and then the secondborns would have to go away, and they went to the across the ocean to the States. So I was wondering whether your bankruptcy story has anything to do with this, because the firstborn is not allowed to fail. And the secondborn, he doesn't have to lose anything. So, he can go bankrupt. It doesn't matter. So, and then something that Jorge said, I think this enforcement against state-owned enterprises is very important. I actually think that his point about the importance of abuse of dominance enforcement makes sense. So if you take a look at the initiatives that come before the Croatian Competition Agency, it's almost every case is about abuse of dominance, some market being foreclosed. But if you look at the enforcement record, if you look at the infringement decisions in the end by the agency, it's barely no abuse of dominance decisions. So there is this balance. So I think maybe people, practitioners, and then this part of the equation, they're still trying to get more information on how to draft a good initiative to start proceedings. So maybe there is some lack of knowledge still there, and there is I think it's hard for the agency to enforce competition law against state-owned enterprises, be it ex-incumbents, be it the current incumbents. It's a very touchy area, and I hope it goes well in future. I hope the agency gets more capacity, gets more stamina for this. But unless competition rules, protection of competitive process is recognized as a value, that we want competition, that we want free markets, I'm not really optimistic about the potential of the competition agency to engage in solving these issues. Thank you so much again for having me on this panel and for all the questions.
So final words are very challenging, no? You have to pick them very well. No. So yeah, Jasminka, and I'm really fascinated about this interaction between culture and law. And the idea is that it's twofold. Not only law must resonate with culture, but there is a shaping. Law shapes the culture and is shaped by that. But we will be too mystical then. And no, I think that the mention of state-owned enterprises raises also another, if you want, cultural and economic example that is very different from the one we discussed, which is China. We didn't have the time to cover the really peculiar relationship of China with competition law. And from what I'm reading, I see that there is a lot of issues, but especially with the state-owned enterprises, the work done there, it's quite remarkable because there are many state-owned enterprises. So a lot of time competition law has to deal with this institution. And perhaps it's another philosophy, no, for sure, it's another philosophy of approaching the market with different ideas. And still there is a competition. So another, for the next conference in person. So thank you very much, Vinícius, Jasminka, Jorge, Eduardo and Juliana. Now I repeat twice. And thank you for the Institute. Really, I was honored.
Well, I just want to say thanks. It has been a pleasure to share with Jasminka and Giacomo. It has been very interesting discussion. And thank you very much as well for the questions that were very challenging and interesting. And thanks to the moderator, Vinícius.
Thank you. Thank you for everyone. So this is the end. For next conference, on person, we're going to discuss China for some hours. Bye.